Hey everybody. Welcome back to the stream. Welcome back to the channel. Welcome back to the videos. Welcome back to everything, pretty much. Welcome back to all of it.
Oh.
Yes, all of it. Glad you're here. This is a really long video, but it's one that I hope will be useful because I've lectured about tonight's topic, today's topic, this video's topic many times on the channel. And it's come up a lot in other discussions on Discord and in my university classes. And that topic is the Toulmin Model. Yes, we all love the Toulmin Model. For those who don't know, but I mean, if you didn't know, like, why would you be watching this video? If you didn't know what the Toulmin Model is, the Toulmin Model is, without a doubt, the most popular and most often cited model of argumentation. That's really all I can say about it that's uncontroversial. I know it probably seems uncontroversial to you, because you're either watching this because you've been assigned it by me, or maybe some other professor has seen this video and is like, this is a very good introduction to the Toulmin Model. I think I'll assign it in my class, which would be great. We love you. We appreciate you. Yeah. Yes. But you might also be watching it because you know a lot about the Toulmin Model and you're here to critique me. You're here to really, try to destroy my point of view. Or you're here to criticize me.
Is that your best?
And all these things are valid. All these are real reasons to do it. But that's why I say it's the least controversial thing I can say. Why is that? Because I think the Toulmin Model is hardly misrepresented in the way it's taught in NCAA-leaning speech communication departments. People, I don't think, understand what he's trying to do. But as a theory of argumentation, what generally ends up happening is it's taught as a way to make arguments, not as a way to understand arguments. And what Toulmin was interested in, Stephen Toulmin was, in his book, Uses of Argument, which we'll be reading from here in a few minutes, is trying to account for why there is a huge distinction and a huge difference between the way that philosophy thinks about argument and the way that arguments happen in the everyday. Now, we're going to just look at section 3 because that's the most appropriate to the model. And in section 3 is where he details the famous model that he's known for, the Big T model. To preview that model, let's take a look at it before we get into the reading, because I think it might help us understand his argument and what he's going for. He's absolutely not interested in teaching you a normative way to argue. This is how it happens and how it happens in the everyday. And it's messy and foggy and unclear, but I think in the hands of people who teach argumentation and debate, people who are debate coaches, it becomes this kind of weapon. The Toulmin model becomes a kind of weapon that's used to say, well, if they don't know their warrant, they've lost. So get the warrant. In cross-examination, ask them for the warrant, or this argument is unwarranted. But this often becomes very, very sloppy and slips around between a lot of the different Toulmin terms. So I think a better understanding of Toulmin and saying, under the perspective that I'm going to offer, which is Toulmin's describing how we naturally engage in this discourse that we call argument. How we do it is based on the everyday, the social, the things that we encounter, and what kind of questions, what kind of things we want to talk about with one another. And that is where he builds the model from. So when people are making arguments to an audience, which is missing in contemporary debate practice, intercollegiate debate or high school debate or what have you, there is no audience. There's the coaches and parents and hired judges and the assistant coaches from other schools who are judging it, who are looking at the technical aspects of a tournament debate, they're going to use and mutilate Toulmin for their own purposes. And it happens all the time. They kind of pick it up and take it to be kind of a claim about how it should be instead of how it is. This analysis that Toulmin offers can help us understand why people assent to arguments, that is, agree to arguments, that we feel are not very good, or why, when there are really, really great arguments, why they don't believe them. So these are the moves that are made. So let's take a look at the model, and I'll give you the kind of the 30,000-foot view, and then we'll get into the text and kind of talk about what Toulmin is saying. So this is the Toulmin model, in its most basic and raw kind of structure, and we'll zoom in on it a little bit and zoom in on some of the features of it. Toulmin's basic model, the model that we all know, and probably the one that gets the most taught, is just this one here, which is referred to as, I refer to it as Toulmin's basic T. The reason I got that from the scholar Barbara Warnick, who was a professor at the University of Pittsburgh when I was doing my Ph.D., and she and I taught at the same time. I never took a class from her. I didn't really spend a lot of time talking to her directly, except in this time when we're waiting for the elevator to go from the communication department on the 11th floor down to the first or second floor to go teach our class, or the basement or the third floor of the Cathedral of Learning, the big super tall tower at the University of Pittsburgh. Go Google it. Go Google it.
Oh.
It's an impressive building.
Oh.
And we'd stand there and talk. She was teaching an advanced argumentation class, and she was saying, I'm just going to have them read Uses of Argument, which is Toulmin's 1958 book. We're just going to read Uses of Argument and go through it in detail and really see what we can get out of it. And she called this the basic T. And I would say this is generally the only thing that's really taught about the Toulmin model in probably 95% of the argumentation and debate classes in the United States. I don't know how it's done in Europe. I would assume the Dutch, the University of Amsterdam, the Dutch School of Argument teach it more detailed. The Canadians probably teach it a little more detailed up in Windsor. The philosophers there, who are the informal logicians, probably add a bit more. But in American books, and even in American books that are argumentative, they don't even take Toulmin as a perspective. They take it as fact. That's the power of his influence. This will appear in any argument textbook, whether it's writing, speech, argumentation. It'll appear as a model, and it'll be centralized on these three terms: data, claim, and warrant. So what are these terms? Well, Toulmin's going to describe them in his own fraught and effervescent language here in a few minutes as we read the book together. But this part right here is just basically data is what's the information, what's the basis of your argument. The claim over here is what is your argument? What are you trying to say? What are you trying to say? And the warrant is unexpressed. It's important to think of, maybe, I don't really have the right color for it here, but sometimes I think it's useful to think of there being a water line. Kind of a water line here. And that water line conceals, the warrant is kind of like what's keeping this thing floating, but it's not really a part of the ship that people really look at. But if it's not there, the ship sinks. That's a way to think about it. The warrant is the adhesive material, social, cultural, language perhaps, assumptions about the world working, things that Aristotle might call logos, common sense, reason, that just underpins that, and it's not ever expressed unless it's directly challenged, and then somebody might express it, but even then, it gets expressed as a claim that then needs its own data and all that. We'll get to that in a little bit. Right, so that's the basic model, the basic Toulmin model that you're going to find in pretty much any book out there about argumentation, even if it claims not to be. In fact, Barbara Warnick wrote a book with Edward Inch that's based on the argumentation theory of Chaim Perlman and Ulbricht Titicob. And that book and its basis is supposedly not Toulmin either. But this model appears in their book as well. So what's that? That's called having an incredibly persuasive, incredibly attractive theory. But maybe it's incredibly attractive for reasons that Toulmin wanted us to get away from. Reasons like clarity, boiling things down, having direct and very clear statements that logically follow from one another, a mechanism of argument. I think he's very much against that. But let's get into the text and we'll see if I'm right. We'll see if I'm right. We'll see if this is what it's going to be. Okay. So here I was looking at this before I started the video. So let us bring it back to the start of section 3, which is a few pages from here. I was kind of digging around. I'm like, Toulmin, my old friend. So in section 3, the layout of arguments is where he talks about his model and how the model works. And this is kind of what I want to read with you in detail with you a little bit. Might be a little bit maybe pedantic. I hope not. But we'll take a look at this together, read it together for a bit, and then I'll give you some commentary as we move through section 3, which isn't a terribly long passage, but it might feel that way if we're like reading it together here on stream, on the video. It might feel kind of long. But we'll get through it. This part here is where he's talking about an argument is like an organism. It has both the gross anatomical structure and a finer, as it were, physiological one. So he's starting immediately with a powerful metaphor, which is what? That arguments are alive. They are living things. Now, this is a great change, a great orientation change in 1958 from the way most people think of arguments, like a logical puzzle, like a geometric proof, like putting statements in order where their validity and their support for each other is something that can be mathematically determined. It can be determined in this real precision. But when we're thinking about life forms, physiology and gross anatomy are, interrelated. Like the physiology of a creature and its anatomy are related in ways that you can't just dismiss, that you have to kind of look at together, understand together, and they're very complicated. So I think that he's kind of making this to say, look, this is going to be very, very muddy, very cloudy. And it's mostly been the physiological part that traditional logicians and traditional argument scholars have been concerned with. And he wants to concentrate on that level deeper. Maybe they've been more focused on the more anatomical ones. We have to concentrate on this level because they have to. But you can't forget what you've learned about the gross anatomy of the beast. It's kind of an interesting thing. So he's going to look at it. We're going to fast forward through this part here because he's kind of justifying what it is that makes his theory necessary. And a couple of things about this section. First of all, he says, maybe we shouldn't have this kind of philosophical precision. So actually, that part might be interesting to talk about. Let's read that part. Ever since Aristotle, it has been customary when analyzing the microstructure of arguments to set them out in a very simple manner. They have been presented in 3 propositions at a time: minor premise, major premise, so conclusion. That's the traditional syllogism of which Aristotle's famous for discussing, and kind of the basis of a lot of the study of logic and argument in philosophy, even today in 2025, which is when I'm making this video. I don't know when you're watching it. The question now arises whether the standard form is sufficiently elaborate or candid. Simplicity is, of course, a merit, but may not be in the case, but may it not in this case have been bought too dearly. So he's saying it's nice to have a simple model, but maybe we paid too much for the simple model, or we're paying for it now. Can we properly classify all the elements in our arguments under 3 headings: major premise, minor premise, and conclusion? Are these categories misleadingly few in number? Is there even enough similarity between major and minor premises for them to usefully be yoked together by the single name of premise? So he's starting to draw in this validity, this deductive reasoning model of argument, kind of say, well, maybe it doesn't really hold water enough for us to really find it useful. Light is thrown in these questions by the analogy with jurisprudence, as the study of the law. This would naturally lead us to adopt a layout of greater complexity than has been customary, for the questions we're asking here are, once again, more general versions of questions already familiar in jurisprudence, and that in more specialized field, a whole battery of distinctions has grown up. What different sorts of propositions, a legal philosopher will ask, are uttered in the course of a law case, and in what different ways can such prepositions bear on the soundness of a legal claim? This has always been, and still is, a central question for the student of jurisprudence, and we soon find that the nature of legal process can be properly understood only if we draw a large number of distinctions. So he's saying that the jurisprudence model only works when you make things more complicated, and there's lots of different distinctions, lots of different statements, and so many differences between this case and the others before it, or similarities, distinctions here, distinctions there. That's what the study is all about. Legal utterances have many distinct functions: statements of claim, evidence of identification, testimony about events in dispute, interpretations of a statute or discussions of its validity, claims to exemption from the application of a law, pleas and extenuation, verdicts, sentences. This is like meant to have the rhetorical pressure of this like fire hose of distinctions that we have to pay attention to. All these different classes of proposition have their parts to play in the legal process, and the differences between them are in practice far from trifling. So there's lots of them, they're all important, and the differences are not, splitting hairs. These differences are actually important, and they're not extra. They're the center of the thing. When we turn from the special case of the law to consider rational arguments in general, now we're moving away from the law to rational arguments of the everyday. We are faced at once by the question, I hope my face isn't covering up some of the things I'm reading. I have to be careful about that. We are faced at once by the question whether these must not be analyzed in terms of an equally complex set of categories. If we are to set our arguments out with complete logical candor and understand properly the nature of the logical process, surely we shall need to employ a pattern of argument no less sophisticated than is required in the law. So that small section alone, section 3, really leans on contemporary interpretations and argumentation and debate textbooks that the Toulmin model clears things up or is a simple pattern for you to follow to generate an argument. That's not what he's saying here. He's saying that the simplicity of Aristotle's philosophical approach immediately is dissolved by the practice of law, where you have to have innumerate distinctions, all of which must be known, and all of which have a role to play, and all of which are extraordinarily important. And he's saying that regular rational argument should be at least as complicated as the law, but I would say it should be more complicated than the law, because the law itself is often kind of a simplifying down of arguments that we would find to be much more complex or require a lot more from everyday argument. That's why people get so frustrated with the law. Like people will say, lawyers, gosh, they get away with so much. That's not what should have happened in that case. It's the court, it's the technicalities. So he's like, it has to be at least that sophisticated. But I think he's hinting here that it's got to be, that's like maybe the starting point for everyday argumentation. I think that's what he's trying to say there. So when you think about how debate is taught now and the importance of the warrant data claim, it's like, okay, what's your warrant? What's your data? What's your claim? As this kind of fill in the blank thing. It's really not at all the application of Toulmin's theory. Okay, the pattern of an argument, data and warrants. This is the important section where we start to get into these terms like I showed you in the model. What then is involved in establishing conclusions by the production of arguments? I like how he puts these little quotes. I had a professor at Pitt who would call them inverted commas. Inverted commas. I think that's very funny. But like he has, it makes me want to do little voices, but I'll spare you. Can we, by considering this question in a general form, build up from scratch a pattern of analysis which will do justice to all the distinctions which proper procedure forces upon us? That is the problem facing us. Let it be supposed that we make an assertion and commit ourselves thereby to the claim which any assertion necessarily involves. That means we're going to assert something to our friends or whoever we're talking to. If this claim is challenged, we must be able to establish it, that is, make it good, and show that it is justifiable. So the distinction is I make an assertion. If people accept it, we don't really need to do much else. They'll be like, yeah, you're right. We're not really in an argument. Now, that's an interesting kind of distinction that some people might be like, wait a second. But it was an argument. I offered an argument, and it was accepted. But he's saying we don't really need to look deeper into that. Now, I think it has the same structure, but maybe it's just a structure where everything is understood so well and agreed to that it's accepted. But then we could push back on that and say, well, fallacies and propaganda could come to bear here, and it might not be the best way. But again, this isn't a normative theory. He's describing how people argue in the everyday. That's the thing I think people miss about Toulmin. The biggest miss. There's a lot people miss about Toulmin, but this is the biggest one. You're going to hear me harp about it a lot in this video. Unless the assertion was made wildly and irresponsibly, we shall normally have some facts to which we can point in its support. If the claim is challenged, it is up to us to appeal to these facts and present them as the foundation upon which our claim is based. Of course, we may not get the challenger even to agree about the correctness of these facts, and in that case, we have to clear his objection out of the way by a preliminary argument. Only when this prior issue, or lemma, as geometers would call it, has been dealt with, are we in a position to return to the original argument. So he's saying that we have facts, we have information that we would base our argument on. But if people don't accept those things as facts or true, then we have to have this other argument about those facts. Now, I would submit that that argument is going to fall into the same Toulmin pattern, which is when people deny your facts, or you have to go clear up the facts and show people that this is really believable stuff, then you have to move into, okay, that's my claim, is that these are facts. What's the data backing that up? What's the warrant, right? So people make arguments and say, oh, that's not a fact. Okay, what do you have to go on? Well, you got it from the New York Times. And then they'll say, okay, well, how do you figure that the New York Times is a bad source? That's where the warrant would come in. The warrant would say, well, because it's from the New York Times, it's unbelievable. And then you would be like, well, how do you figure that? And then you go on to the backing. So it goes in these different steps of what comes out that people won't say because they think it's too obvious to be said. And also it takes away from the rhetorical power of the argument, I'd say, when you have to list everything out in this formal way. The really good stuff about argument, its lifeblood, its physiology kind of melts away into the air, evaporates into the ether, and you don't really get that powerful argument like you get when it's stated in that normal way. We can talk about that a little bit more after we finish this. I'm getting a little ahead of myself. But this complication we need only mention. Supposing the limit to have been disposed of, our question is how to set the original argument out most fully and explicitly. Harry's hair is not black, we assert. What have we got to go on? We are asked. Our personal knowledge is that it is in fact red, that it is our datum, the ground on which we produce as a support for the original assertion. So data, datum, and ground are synonyms for that first part of the Toulmin model, which I will show you. The part called data over there all by itself, that's the part that's either, some people call it ground, some people call it datum, all kinds of things, because those words are synonyms for Toulmin in his discussion of the theory. Should I be up in the corner just like I am in the other one? Is this better? Yeah, it's probably better. The ground which we produce is a support for the original assertion. So that's data claim. That's the two parts right there. Peterson, we may say, will not be a Roman Catholic. Why? We base our claim on the knowledge that he's a Swede, which makes it very unlikely that he will be a Roman Catholic. These examples, Toulmin's examples, are wild. But if you really want to see some crazy examples, look at Chaim Perlman and Lucy Ulbricht's examples. Those are really crazy, if you think these are crazy. But we're going to talk about Roman Catholic Swedes for quite a bit in this video. It comes up quite a bit in this section. We base our claim on the knowledge he's a Swede, which makes it unlikely he will be a Roman Catholic. Wilkinson, asserts the prosecutor in court, has committed an offense against the Road Traffic Acts. In support of the claim, 2 policemen are prepared to testify that they timed him driving at 45 miles an hour in a built-up area. In each case, an original assertion is supported by bearing other facts bearing on it. Facts. Facts. That's an interesting understanding of that word based on how we look at it today. Let's look at these examples more closely. Harry's hair is not black. Our personal knowledge is that it's red. Is that a fact? My personal relationship, I know this guy, Harry, he doesn't have black hair. You can see this argument playing out as we're waiting for Harry at dinner. So I say, I think he just walked in. I say, well, Harry's hair is not black. Oh, yeah, well, I know him. I've met him before. Oh, okay. End of the argument. That would be enough. That datum would be enough to convey the force, the persuasive authority of the claim. That would be enough to make it convincing. Peterson's not a Roman Catholic. He's Swedish. Oh, Now that's based on like history, is it maybe? Is that a fact? Is history a fact? Social norms, cultural norms, do those have the weight as a fact? His understanding of fact is very different than the way we talk about it in 2025, and I think the way we talk about it in 2025 is really impoverished, isn't it? Like these things are not necessarily what we think about facts. We just think of it as scientific data, statistics. We have this very thin conception of fact today. Here's another fact. 2 police officers are going to provide sworn testimony. Is that a fact? That's testimony. Is testimony a fact? Well, for Toulmin, all these things classify as fact, classify as datum. But I think modern times when you're teaching Toulmin to contemporary undergraduates or to contemporary students of any kind, you want to think about facts as like information. Because the idea of disputing facts has a very different, since 2016, disputing facts has a very different sense to it, like fake news. The MAGA Trump epistemic turn in American politics has infected everything to where people are like, oh, my doctor said I should get this vaccine. That's not factual. That's my doctor's opinion. But still, that doctor's opinion would serve as the datum, as the data, regardless of contemporary notions of it. That's what Toulmin means. Okay. We already have, therefore, one distinction to start with between the claim or conclusion whose merits we are seeking to establish, C, and the facts we appeal to as a foundation for the claim, what I shall refer to as our data, D. If our challenger's question is, what have you got to go on, producing the data or information on which the claims are based may serve to answer him. But it is only one of the ways that our conclusion can be challenged. Even after we produced our data, we may find ourselves being asked further questions of another kind. We may now be required not only to add more factual information to that which we have already provided, but rather to indicate the bearing on our conclusion of the data already produced. Colloquially, the question may now be not what have you got to go on, but how do you get there? To present a particular set of data as the basis for some specified conclusion commits us to a certain step, and the question is now about the nature and justification of this step. So he's saying here, in other words, that every time we produce data for a claim, it might not be enough because there might be an inference there, a step. We've taken a logical leap or a reasoned leap, and our interlocutor, the person listening to us, might not either see it or they might see it and not believe it. Those are two different kinds of questions other than, well, what are you basing your argument on? Okay, how do you get there from that data to the claim? Or I see how you get there. How in the world do you figure that works? These are the kind of responses that we're talking about with this other new term. Spoiler alert. Spoiler alert. It's the warrant. Supposing we encounter this fresh challenge, we must bring forward not further data for about the same query may immediately be raised again. That's when you're like, yeah, but this and this, and you did this and this. And they're like, yeah, but I don't understand why that disqualifies them from coming to dinner with us. I don't see how you see that. Or, yeah, I get all that information, but why does that mean I should change my habits? That's what they're asking for. Kind of more the persuasive force rather than the factual force. But propositions of rather different kind. Rules, principles, inference, licenses, or what you will, instead of additional items of information. Our task is no longer to strengthen the ground on which our argument is constructed, but it is rather to show that taking these data as a starting point, the step to the original claim or conclusion is an appropriate and legitimate one. That is, this data legitimately supports the claim. A different argument than the data is true or false, or the data is good or it's not factual, or it's alternative facts. At this point, therefore, what are needed in our general hypothetical statements, which can act as bridges and authorize the sort of step to which our particular argument commits us. These may normally be written very briefly. Now, this is kind of like predicate logic or mathematical logic. If you've taken a logic class, you might recognize this in the form of if D, then C. But for candour's sake, they can profitably be expanded and made more explicit. Data such as D entitle one to draw conclusions or make claims such as C, or alternatively, given data D, one may take it that C. Now, might seem to you to be, wait a second, you said earlier, Toulmin's trying to move away from formal logic, philosophical formal logic reads of argument. And I say yes. but his audience is that of formal logicians and people who study argument from philosophy. Toulmin gets his advanced degree, his doctoral degree from Cambridge in philosophy. So he is a philosopher. He's speaking to other philosophers with this book and trying to broaden their sense. I think if he was writing to other people, he would have changed his tone. That's what the universal audience theory shows us. But he's trying to make the best case possible. And this is a nice comparison to the way that formal logic structures claims. I think it's kind of a nice way to do that. So given data D, one may take it that C. This is the realm of the warrant, which is it entitles us, it licenses us, is appropriate when you have this kind of data to draw these conclusions, and that's what the warrant says. And here he goes right into it. I didn't spoil too much, did I? I didn't spoil too much. I think we're still pretty good. Propositions of this kind I shall call warrants to distinguish them from both conclusions and data. These warrants, it will be observed, correspond to the practical standards or canons of argument referred to in our earlier essays. So you'll have to go and look at that. I didn't talk about that in the earlier essays in the book, the earlier chapters. To pursue our previous examples, the knowledge that Harry's hair is red entitles us to set aside any suggestion that is black. On account of the warrant, if anything is red, it will also not be black. The very triviality of this warrant is connected with the fact that we are concerned here as much with counter-assertion as with an argument. So this is a very kind of a logical warrant, but there also could be the warrant which is, well, if you've personally met someone, you would know their hair color, which also would be a warrant you could put in there too. But like you said, the triviality of it is that we're concerned as much with a counter-assertion as with an argument. A little bit more formal in the presentation. But if I was writing this, I would say, no, I think it's more of that. It's that, but it's also maybe more of like, well, I've met him. And then you can move the argument column to be like, okay, well, where did you meet him? And for how long did you meet him? And was he wearing a hat? And these could be the kind of arguments you have to fight back against on the warrant. The fact that Peterson is a Swede is directly relevant to the question of his religious denomination. For as we should probably put it, a Swede can be taken almost certainly not to be a Roman Catholic. The step involved here is not trivial, so the warrant is not self-authenticating. I think the earlier one might have been self-authenticating. If something is red, it cannot also be black. But I don't know how self-authenticating that is. I think that this one is a little bit more debatable. That is, it's a probability warrant. But given the history of Sweden and the religion there, most likely, very, 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 very rare chance of a Roman Catholic Swede, given what we know about the history and the culture and the society and religious beliefs in Sweden. Likewise, in our third case, our warrant will now be some such statement that a man who is proved to have driven more than 30 miles an hour in a built-up area can be found to have committed an offense against the Road Traffic Acts. Yes. The question will at once be asked, how absolute is this distinction between data on the one hand and warrants on the other? Great question, because I think a lot of times these things get mushed together quite a bit, and it might be useful to distinguish them as separate parts of the argument so that we can better understand human reasoning as it happens in kind of the everyday. Will it always be clear whether a man who challenges an assertion is calling for the production of his adversary's data or for the warrants authorizing his steps? Can one, in other words, draw any sharp distinction between the force of the two questions? What have you got to go on? And how do you get there? By grammatical tests alone, the distinction may appear far from absolute. And the same English sentence may serve a double function. Oops, I did the thing. There we go. It may be uttered that this, in one situation, to convey a piece of information, and another to authorize a step in an argument, and even perhaps in some context do both of these things at once. All these possibilities will be illustrated before too long. For the moment, the important thing is not to be too cut and dried in our treatment of the subject, not to commit ourselves in advance to rigid terminology. Again, he's trying to get away from that philosophical rigidity of validity and these kind of things like, does this count as this, does this count as that? At any rate, we shall find it possible in some situations to distinguish clearly two different logical functions, and the nature of this distinction is hinted at if one contrasts the two sentences. Whenever A, one has found that B, and whenever A, one may take it that B. Now, that's a very interesting distinction. I think in the time he's writing, I kind of agree with that now, but in today's contemporary debate and argument world, I think it is important to maybe have a little bit more of a rigid distinction so that you know what you are addressing and what you are answering. When you're debating or arguing with someone, you kind of know what it is they're trying to get from you, what it is they're trying to ask. So whenever A, one has found B, and whenever one may take it that B, the difference between grounding in the first one and a warrant in the second one. Some are much more direct and trivial, as the hair example, the black-red hair example. One thing can't be two colors at once, but maybe it can be. I don't know. But that's kind of where he's coming from. So he doesn't want us to get bogged down with like philosophical definitions of data and warrant, but he does want us to know that when people are asking for, I mean, also people can say, well, what do you have to go on? People could argue and give the data and the warrant at the same time, even without it being asked for. So people can voluntarily give this kind of information out. But I think it's important to note that there's more than just facts at work here. The way that we think about arguing with people is accept the facts. And there's more than facts working here in the Toulmin model. And when you conflate the warrant in the ground as data or reasons, you're not using the model to its fullest power to try to show what might be wrong with an argument, or more importantly, what might be right with an argument, or being able to explain it to different kinds of audiences, which I think is the rhetorical power of Toulmin's theory. Toulmin didn't really like, I think, the take-up of this book in rhetoric. He wanted it to be more of a philosophical book, and he didn't really like how American speech comm departments just kind of embraced it and wouldn't let it out of their claws. And it still appears in that, and in writing rhetoric too. It appears in a lot of writing rhetoric books too on argument. We now have the terms we need to compose the first skeleton of a pattern for analyzing arguments. This is going to look familiar. We may symbolize the relationship between the data and the claim in support of which they are produced by an arrow and indicate the authority for taking the step from one to the other by writing the warrant immediately below the arrow. So data leads to claim since warrant, right? So it's kind of going this way. I can't really edit this book. Yeah, okay. That's too bad. I was hoping to edit the book, but it does not work that way. Harry was born in Bermuda, so Harry's Bermuda subject, since a man born in Bermuda will be a British subject. There's the example, another weird one. I don't know where Toulmin gets his examples. They're kind of odd. He would think he would take something a little bit more dicey, but I think he, as a philosopher, he's trying to prove the simple case to give you a pattern or a model to look for the more complicated case, maybe. Maybe he's doing us a favor. I don't know. As this pattern makes clear, the explicit appeal in this argument goes directly back from the claim to the data relied on as its foundation. Here's what I believe, and here's why. The warrant is, in a sense, incidental and explanatory, its task being simply to register explicitly the legitimacy of the step involved and refer it back to the larger class of steps whose legitimacy is being presupposed. So the warrant is making a couple of moves. One is that it's incidental. It's just like, well, here's why this is legitimate. It answers the question of why is this connection between data and claim legitimate, but also it legitimizes a whole class of reason. He's saying that here. They refer it back to the larger class of steps whose legitimacy is being presupposed. So the person making the argument is presupposing that that step is legitimate in a lot of different ways, and the warrant helps with that. This is one of the reasons for distinguishing between data and warrants. Data are appealed to explicitly, warrants implicitly. In addition, one may remark that warrants are general, certifying the soundness of all arguments of the appropriate type, and have accordingly to be established in quite a different way from the facts we produce as data. This distinction between data and warrants is similar to the distinction drawn in the law courts between questions of fact and questions of law. And the legal distinction is indeed a special case of the more general one. We may argue, for instance, that a man whom we all know to have been born in Bermuda is presumably a British subject simply because the relevant laws give us a warrant to this conclusion. So we're back to the legal metaphor. And he's saying the warrant is much more like the legal question and the legal argument. And the other one is question of fact, information. So, when judges are asking for the questions of fact or facts of the case, asking for one thing, and the questions of law is like, why and how is the law applied, or in this situation, why is that law the appropriate one? How does it work? How does the law work? How the facts of the information work? So it's kind of interesting. It also kind of shows me, when I think about this part, I think more about how everyday life and how law is based on kind of everyday life reasoning, and really isn't that complicated or complex. And we kind of give lawyers and people with legal training a bit more credibility in argumentation that I think we all kind of have naturally. We just can't explain it in more specific terms. So maybe that's another advantage to the Toulmin model, is it allows us to explain our everyday reasoning in professional terms or professional guise. or to show how professional modes of argument come from this kind of everyday argument, this kind of everyday reasoning or verbal reasoning. One more general point in passing: unless in any particular field of argument we are prepared to work with warrants of some kind, it will become impossible in that field to subject arguments to rational assessment. The data we cite, if a claim is challenged, depend on the warrants we are prepared to operate within that field, and the warrants to which we commit ourselves are implicit in the particular steps from data to claims we are prepared to take and to admit. But supposing a man rejects all warrants, whatever, authorizing steps from data about the present and past to conclusions about the future, then for him rational prediction will become impossible. And many philosophers have in fact denied the possibility of rational prediction just because they thought they could discredit equally the claims of all past to future warrants. That's an interesting paragraph to put there, is that he's like, you have to, if you want to work rationally, and if you want to be able to engage an argument, you can't really dismiss all kinds of warrants. You have to accept some of them. Some of them. So he gives the example of in philosophy, they dismiss all prediction because they could just discredit equally the claims of all past to future warrants without the context or the specifics of it. This is the kind of thing he's trying to get away from, is this universal, like, well, if you make a warrant like that, you're always going to be wrong. I mean, this kind of sounds like it's taught in intercollegiate debate. I hate to say it. But I hear this kind of teaching a lot. And you hear it in high school debate too. If people make this kind of connection, it's always faulty. Kind of like a fallacy, like a bad way of teaching fallacy as a disqualifying step. So, yeah, you have to be able to work with warrants of some kind. It has to be field. It has to be a little loosey-goosey. Warrants are loosey-goosey is kind of what he's saying. Loosey-goosey technical term that I'm sure everybody is aware of. Has to be a little loose, a little foggy. I mean, why wouldn't you want an argumentation theory that operates in the fog and in the shadows and that kind of thing? Of course you would want that. The skeleton of a pattern which we have obtained so far is only a beginning. Further questions may now arise to which we must pay attention. Warrants of different kinds and may confer different degrees of force on the conclusions they justify. So there's different kinds of warrants. Some warrants authorize us to accept a claim unequivocally given the appropriate data. These warrants entitle us in suitable cases to qualify our conclusion with the adverb necessarily. So a necessary warrant because of something that we know in the relationship. Others authorize us to make the step from data to conclusion either tentatively or else subject to conditions, exceptions, qualifications. In these cases, other modal qualifiers such as probably, presumably are in place. It may not be sufficient, therefore, simply to specify our data, warrant, and claim. We may need to add some explicit reference to the degree of force which our data confer on our claim in virtue of our warrant. In a word, we may have to put in a qualifier. So the qualifier is about the force under which the warrant operates. So you see the qualifier here. The qualifier really should, I don't think I'm happy with that. The qualifier often is placed over there, but let me change it. It is my model after all. So maybe we can put the qualifier here, like that. And you move it down here with the warrant. And then maybe get rid of that line. Oh, that's kind of a weird looking. I don't know if I like that arrow either. This program I'm using called Miro. I really like it. Okay. If you like it, you can go to Miro, M-I-R-O. Google that. Sign up for an account. It's a really great whiteboard tool. And very good price. Very good thing to use. So the qualifier shows us the intensity of the warrant. We'll see where Toulmin puts it. I'm curious where he puts it. I'm thinking with what he just said, I'd rather put it down there because it's talking about under what force and conditions we accept that warrant. Again, it is often necessary in the law courts not just to appeal to a given statute or common law doctrine, but to discuss explicitly the extent to which this particular law fits the case under consideration. Whether it must be inevitably be applied in this particular case, or whether special facts may make the case an exception to the rule, or one in which the law can be applied only subject to certain qualifications. So again, we're back to the legal metaphor, dealing with human affairs. I think maybe the legal metaphor is good because he's interested in an argument that deals with human affairs, such as human perception, human belief, the human world, rather than philosophical argument, which is dealing with what is true, whether there's humans there or not. That kind of argumentation that is sort of objective validity. Whether or not humans believe it or whether or not it makes sense to humans is irrelevant because it's structurally true. He's trying to get away from that kind of pure, precise, logical, deductive argumentation. He wants to dismiss that and say that this theory is a little bit more amenable to understanding the physiology of arguments about human. I think it's about human affairs. That's what I'm starting to think as we're going through this together. If we were to account of these features of our argument, also our pattern will become more complex. Modal qualifiers and conditions of exception or rebuttal are distinct both from data and from warrants and need to be given separate places in our layout, just as a warrant itself is neither a datum nor a claim, since it implies in itself something about data and claim, namely that the step from the one to the other is legitimate. So in turn, qualifiers and rebuttals are themselves distinct from warrants, since they comment implicitly on the bearing of warrants on this step. Qualifiers indicating the strength conferred by the warrant on this step, conditions of rebuttal indicating circumstances in which the general authority of the warrant would have to be set aside. So these are qualifying moments that kind of show under what conditions, I always teach, under what conditions the arguer would defend things. So the qualifier shows us the strength of this warrant coming over here, but the rebuttal shows us the conditions under which we wouldn't defend the claim. These conditions are no longer, if the claim appears under these conditions, the warrant no longer has any sway, or under these conditions, the qualifier means you have to accept it, or you would accept it probably or possibly. So the red hair, black hair would be a qualifier, would need a qualifier, would be a necessarily so. If something is black, it cannot be red, vice versa. But under the Peterson is a Swede example, it'd be like, well, presumably, since he's Swedish, he's not Roman Catholic. Or in the law courts example, it would be like, unless there is evidence that the radar gun wasn't used, or the police didn't saw the wrong vehicle, or there's not enough, these are the moments in which he wouldn't be found guilty. So as you can see, he is creating a very complicated theory of argument, much more complicated than is it true, is it factual, is it valid, which unfortunately is what most people lean on when they're arguing. And this is a much better model, I think, for that. To illustrate our claim that, so here's where he's putting it. So he puts the qualifier here, unless R. So this is all right before the claim. So I did mine wrong, but that's okay. I like my model. But so, qualifier, claim, unless, rebuttal. Our claim that here is a British subject may normally be defended by an appeal to the information he was born in Bermuda. For this datum leads to support our conclusion on account of the warrants implicit in the British Nationality Acts. The argument is not itself conclusive in the absence of assurances about his parentage and about him not having changed his nationality since birth. What our information does is to establish that conclusion holds good, presumably, and subject to the appropriate provisos. This argument now assumes the form, Harry is born in Bermuda, since a man born in Bermuda will generally be a British subject. So presumably, Harry is a British subject unless both his parents were aliens, he's become a naturalized American, etc. We must remark, in addition, on two further distinctions. The first is that between a statement of a warrant and statements about its applicability, between a man born in Bermuda will be British, and this presumption holds good, provided his parents were not both aliens, etc., the distinction is relevant not only to the law of the land, but also for an understanding of scientific laws or laws of nature. It is important indeed, in all cases where the application of a law will be subject to exceptions, or where a warrant can be supported by pointing to a general correlation only and not to an absolutely invariable one. We can distinguish also two, that's kind of an interesting line. So, it's when we're talking about scientific laws or laws of nature, those exceptions are not absolutely invariable. We are pointing to correlation, not absolute invariability. And so this is a very important way to make arguments more reasonable, more rational, easier to follow, and make them a little bit more convincing and true. We can distinguish also two purposes which may be served by the production of additional facts. These can serve as further data, or they can be cited to confirm or rebut the applicability of a warrant. Thus, the fact that Harry was born in Bermuda and the fact that his parents were not aliens are both of them directly relevant to the question of his present nationality, but they are relevant in different ways. The one fact is a datum. It's data, it's the D, by which itself establishes a presumption of British nationality. The other fact, by setting aside of one possible rebuttal, tends to confirm the presumption thereby created. So when you use that data to refute the warrant, or to refute the rebuttal, you're doing something very different than adding more data to lead to the strength of the warrant. But when you refute the rebuttal, you make the warrant a little bit stickier, a little bit more powerful. One particular problem about applicability we shall have to discuss more fully later when we set out a piece of applied mathematics in which some system of mathematical relations is used to throw light on a question of, let's say, physics. The correctness of the calculations will be one thing. Their appropriateness to the problem in the hand may be another. So the question is this calculation mathematically impeccable? May be a very different one from the question, is this the relevant calculation? Here, too, the applicability of a particular warrant is one question. The result we shall get from applying the warrant is another matter, and in asking about the correctness of the result, we may have to inquire into both things independently. So this is kind of interesting, and I think this is a great way to think about the power of having data, warrant, qualifier, rebuttal, because you have many, many different ways to question an argument to make sure you're assenting to something good, instead of collapsing everything into, is it factual, is it true, is it credible? Instead of collapsing it into one term, having the multiple terms allows different ways to question. So the math example might be, are these calculations correct? Yes, they are. If you have a thin view of argument, that's all you really need to do. But you could say, okay, I might stipulate they're correct, I might agree with you, but is this the appropriate way to address this question? And so this is where the warrant comes in handy, because the data correctness of the information, or the truth of it, or the factacity of it, factual information, might not help you judge whether or not that information is also relevant to the decision you're trying to make. This happens all the time in presidential debates, where the news media trying to be helpful, but journalists not being incredibly sharp about these kind of distinctions will just be like, well, it is a fact that, that candidate did say a fact and that candidate didn't say a fact. But never is the question asked, is this fact relevant to us determining whether or not they should be president? Never happens. Pattern of an argument, backing our warrants. One last distinction, which we have already touched on in passing, must be discussed at some length. In addition to the particular question, in addition to the question whether or not, I can't see it, that's why I can't read it, whether or on what conditions a warrant is applicable in a particular case, we may be asked why in general this warrant should be accepted as having authority. So this is now another level of objection, where you can say, I don't think that kind of reasoning should be accepted, like criticizing the force behind even that kind of step, the actions of that step. In defending a claim, that is, we may produce our data, our warrant, and the relevant qualifications and conditions, yet find we still have not satisfied our challenger. For he may be dubious not only about this particular argument, but about the more general question whether the warrant is acceptable at all. Presuming the general acceptability of this warrant, he may allow our argument, would no doubt be impeccable. If data-ish facts really do suffice as backing for claim-ish claims, then all is well and good. But does not the warrant in turn rest on something else? Challenging a particular claim may, in this way, lead on to challenging more generally the legitimacy of a whole range of arguments. Remember his example back up there where he talked about not believing that you can draw any conclusions about the future from the past? That'd be a big challenge. You presume that a man born in Bermuda can be taken to be a British subject, you may say. But why do you think that? Standing behind our warrants, as this example reminds us, there will normally be other assurances without which the warrants themselves would possess neither authority nor currency. These are the things we may refer to as the backing of the warrants. This is the part hardly ever taught in debate. This backing of our warrants is something which we shall have to scrutinize very carefully. Its precise relations to our data, claims, warrants, and conditions of rebuttal deserve some clarification, for confusion at this point can lead to trouble later. We shall have to notice particularly how the sort of backing called for by our warrants varies from field of argument to another. Now, this is another part of the book that I didn't talk about. This is the first part where he says all argumentation is field dependent. That is, it's hard to evaluate whether an argument is true or good, or that evidence is good, or that a connection is good, without knowing the field in which the argument is occurring. Like, who are we talking to and who's talking, is what he means by field dependency. So this form does not vary between fields, this basic form. This is the more basic T with qualifiers and rebuttals and all that we just discussed. that those elements do not change from field to field. The backing might change though. So now we have this sense, and we can describe all these parts. Data is the information or facts, whatever we're drawing on. The claim is what we think this data proves. The warrant is the explanation process of how we make that leap or that jump from the data to the claim. The qualifier is the force of the warrant. Is it necessarily so? Is it probably so? Is it possible? Under what conditions the warrant, how strong is the warrant? And then rebuttal is what conditions will we not defend our claim? Then we have the backing, which is way down here behind the warrant. That's the next one that he's going to discuss. So, go back to the text. A whale will be a mammal. A Bermudian will be a Briton. A Saudi Arabian will be a Muslim. Here are 3 different warrants to which we might appeal in the course of a practical argument, each of which can justify the same sort of straightforward step from a datum to a conclusion. We might add for a variety examples of even more diverse sorts taken from moral, mathematical, or psychological fields. But the moment we start asking about the backing, which a warrant relies on in each field, great differences begin to appear. The kind of backing we must point to if we are to establish its authority will change greatly as we move from one field of argument to another. A whale will be classifiable as a mammal. A Bermudian will be, in the eyes of the law, a Briton. A Saudi Arabian will be found to be a Muslim. These words in parentheses indicate these differences. That's so interesting, right? These are the kinds of differences in fields about how these connections will be made, how the backings will be as we move differently between fields, found to be, classifiable as, in the eyes of the law, depending on what field you're talking about. One warrant is defended by relating it to a system of taxonomical classification, another by appealing to the statutes governing the nationality of people born in the British colonies, a third by referring to the statistics which record how religious beliefs are distributed among people of different nationalities. Those are all 3 very different kinds of reasoning. We can, for the moment, leave open the more contentious question, how we establish our warrants in the fields of morals, mathematics, and psychology. For the moment, all we are trying to show is the variability or field dependence of the backing needed to establish our warrants. So he's saying here that backing is going to be very different based on who we're arguing to and under what standards we're arguing and what field we find ourselves in. Legal, statistical, sociological, statistical, or biological, scientific. And the warrant, when we look to the backing, the backing is going to be much, much more field dependent than anything else. We can make room for this additional element in our argument pattern by writing it below the bare statement of warrant for which it serves as backing. On account of B, I think that's a great way to think about it, is on the account of, so a whale is a mammal because mammals are da-da-da on account of the taxonomy of a mammal, da-da-da-da. This form may not be final, but it will be complex enough for the purpose of our present discussions. To take a particular example, in support of the claim that Harry is a British subject, we appeal to the datum that he was born in Bermuda, and the warrant can then be stated in the form, a man born in Bermuda be taken to be a British subject, since, however, questions of nationality are always subject to qualifications and conditions. We shall have to insert a qualifying presumably in front of the conclusion, and note the possibility that our conclusion may be rebutted in case it turns out both of his parents were aliens or he has become a naturalized American or a citizen of some other country. Finally, in the case the warrant itself is challenged, its backing can be put in. This will record the terms and the dates of the enactment of the Acts of Parliament and other legal provisions governing the nationality of persons born in the British colonies. So this is like if the warrant is, because that's the law, they'd be like, well, how do you know that that's the law? You would say the backing, well, these specific laws work in this way. Or you'd say, well, that's how legal decisions are made. And they're like, I don't think that's how they're made. Then the backing would be, well, let's look at how the law works. And that would be what the backing does. But again, it's field dependent. It's not so obvious to be objective or to be valid in all cases. It's going to rely specifically on the operations of a field under which the credibility of the arguments are going to be believed. The credibility of what you're saying is going to be believed. It's not objective and it's not true in all cases, but it's true in terms of the field that you're arguing in. So there's the full example with the backing. In what ways does the backing and warrants differ from the other elements in our arguments? To begin with, the differences between backing and warrant. Statements of warrants we saw are hypothetical, bridge-like statements, but the backing of warrants can be expressed in the form of categorical statements of fact, as well as can the data applied to in direct support of our conclusions. So as long as our statements reflect these functional differences explicitly, there's no danger of confusing the backing for a warrant with the warrant itself. Such confusions arise only when these differences are disguised by our forms of expression. So maybe sometimes we're not clear enough, or we use equivocal language maybe. In our present example, at any rate, there need be no difficulty. He's saying sometimes it might be difficult to pull these things apart if you're in a very complex kind of argument. Like imagine if you're saying, well, the law says, da-da-da-da-da, the datum would be the law, and the conclusion is, well, the law says that that person should be in jail. I say, well, how do you figure? Well, there's a law that this kind of action is illegal. And they'd be like, what law are you talking about? Then the backing would bring that law up. So it'd be a lot more like datum, a lot less like warrant in that case. But sometimes the backing is a lot more like warrant, particularly if you're arguing historical things or maybe anthropological things about the general assumptions we make about civilization, society, and what they have. So if we see the presence of this, if you see the presence of spoke to wagon wheels, then we might think this civilization will have this, this, and this as well. That might be the kind of backing that sounds more like a warrant. So it goes in between, and it's kind of confusing. But as long as we're very clear about it and we think carefully and look at it carefully, we won't run into trouble. The fact that the relevant statutes have been validly passed into law and contain the provisions they do can be ascertained simply by going to the records of the parliamentary proceedings concerned in the relevant volumes in the books of statute law. The resulting discovery that such and such a statute enacted on such and such a date contains a provision specifying that people born in the British colonies of suitable parentage shall be entitled to British citizenship is a straightforward statement of fact. On the other hand, the warrant, which we apply in virtue of the statute containing this provision, is logically of a different character. If a man was born in a British colony, he may be presumed to be British. Now that's the difference between the warrant and the backing in this case, is that the warrant always implies a leap. The backing does not necessarily imply a leap. Though the facts about the statute may provide all the backing required by this warrant, the explicit statement of the warrant itself is more than a repetition of these facts. It is a general moral of a practical character about the ways in which we can safely argue in view of these facts. We can also distinguish backing from data. Though the data we appeal to in an argument and the backing lending authority to our warrant may be stated as straightforward matters of fact, they always are. Well, backing maybe not so much. It can look like a warrant. The roles for which these statements play in our argument are decidedly different. Data of some kind must be produced if there is to be an argument there at all. That's an interesting claim. So I have to have some kind of fact or information backing if we're going to have an argument at all. If I'm just like, no, I'm just asserting it, we're no longer in the realm of argument for Toulmin. It's like, nothing, I just feel that way. I mean, maybe that's data. I just feel that way. Not much of a data, but we deal with this kind of stuff all the time. I just think it's right. That's not really data either. Data would be the information or the phenomena or something that you're using to back your conclusion on. I guess those things would be data in a strange kind of way, but we don't really like to think of them as our preferred data, but they would be. But then the warrant for why I should believe what you feel in your heart isn't that clear. It's not a jump that we'd be prepared to make, so that argument might be defeated by the fact we say, I'm not prepared to make a jump based on how you feel in your heart. I mean, it might not be enough for me. Sorry to say. Yeah, I know. It hurts. A bare conclusion without any data produced in its support is no argument, but the backing of the warrants we invoke need not be made explicit. At any rate, to begin with, the warrants may be conceded without challenge, and their backing left understood. That's how a lot of arguments go down. Oh, yeah, I agree. Yeah. Or like, oh, yeah, I see where you're coming from. But then maybe I check the data, or maybe I offer a counterclaim, or I start talking about the rebuttal, and we argue there, and it's just accepted. Indeed, if we demanded the credentials of all warrants at sight and never let one pass unchallenged, intercollegiate debate, argument could scarcely begin. Yeah, what is the warrant for that card? What is the warrant for that? What is it? It's just nonsense. Jones puts forward an argument invoking warrant W1, and Smith challenges that warrant. Jones is obliged as a lemma to produce another argument in the hopes of establishing the acceptability of the first warrant, but in the course of this lemma employs a second warrant, W2. Smith challenges the credentials of the second warrant in turn, and so the game goes on. That sounds like many a debate that I've been forced to watch early in the morning because of, maybe bad decisions of how to spend my time. Some warrants must be accepted provisionally without much further challenge. If an argument is to open to us in the field in question, we should not even know what sort of data were of the slightest relevance to a conclusion if we had not at least a provisional idea of the warrants acceptable in the situation confronting us. So we kind of have to give a little leeway in order to understand the argument, to know exactly where it is that we'd like to challenge it, if we'd like to challenge it at all. The existence of considerations such as would establish the acceptability of the most reliable warrants is something we are entitled to take for granted. That sounds a lot like universal audience theory in Perlman and Ulbricht's Titico, which is that there are the most reliable warrants, and we would accept those conditions as a precursor to being able to argue or engage with claims at all. I think it's a really important consideration. Instead of like, well, there's no warrant, we're dismissing everything you're saying. It's almost like the Toulmin fallacy in a way at that point. When people argue that way, they just continuously challenge warrants. Well, that warrant, I don't accept that warrant, I don't accept that warrant. It's like bad internet debate. Finally, a word about the ways in which backing differs from qualifying rebuttal. These are too obvious to need expanding upon, but he's going to do it anyway because he's a Cambridge-trained philosopher. Since the grounds for regarding a warrant as generally acceptable are clearly one thing, the force which the warrant lends to a conclusion another, and the sorts of exceptional circumstance which may in particular cases rebut the presumptions the warrant creates a third. They correspond, for example, to the three statements that statutes about British nationality have in fact been validly passed into law, and say this, that Harry may be presumed to be a British subject, and that Harry recently having become a naturalized American is no longer governed by these statutes. One incidental point should be made about the interpretation to be put upon the symbols in our pattern of argument. This may throw light on a slightly puzzling example, which we came across when dealing with Neil's views on probability. Consider the arrow joining D and C. It may seem natural to suggest at first this arrow should read as so in one direction, as because in the other. So it's like, this exists, so data exists, so claim. Or claim because data, the two different words we could put there. Other interpretations are, however, possible. As we saw earlier, the step from the information that Jones has Bright's disease to the conclusion that he cannot be expected to live to 80 does not reverse perfectly, right? There's no like, what would that be called, modus ponens? Is that the correct logical? I'm not a logician, but it doesn't reverse perfectly, so it wouldn't be an example of that. We find it natural enough to say Jones cannot be expected to live to 80 because he has Bright's disease. But the fuller statement, Jones cannot be expected to live to 80 because the probability of his living that long is low because he has Bright's disease, is cumbrous and artificial, for it puts an extra step which is trivial and unnecessary. So this desire for accuracy and clarity ironically interrupts the ability of the argument to hold sway or have force or to be something that people would want to engage in it. It just seems oddly pedantic and oddly hyper-structured when we're going for this kind of clarity in it. On the other hand, we do not mind saying Jones has Bright's disease, so the chances of his living to 80 are slight, so he cannot be expected to live that long. For the last clause is, so to speak, an inter alia clause. It states one of the many particular morals one can draw from the middle clause, which tells us his general expectation of life. So also in our present case, reading along the arrow from right to left, from left to right, we can normally say C because D and D so C, but it may sometimes happen that the more general conclusion that C may be warranted. Given D, where this is so, we shall often find it natural to write not only D so C, but also D so C1, so C, what is that, prime or something? I don't know what that is. So C being the more general conclusion warranted in the view of data, D, for which in turn we infer inter alia that C. So we might want to defend a more narrow claim, but the data defends a larger claim, and we just want to take the ground and argue that smaller claim, but we are lapsing or leaving out that step of having to defend the larger truth of the claim first. That is, the data supports a claim that's much bigger than what we want to defend, but what we want to defend is under that larger claim, so the data supports it. Okay, so that is the end of that. I think that looking at this now, we understand a few things about, after we actually read the section, a few things about the Toulmin model pop out, which is the Toulmin model is an incredibly practical tool for trying to figure out what it is someone's saying to you and under what conditions they'll defend it and under what conditions you should agree to it. It's also a really beautiful way to understand evidence that you're reading, and like in a book or talking to somebody, things that you want to use for proving your own argument when you're looking at evidence. Testing yourself to see if you can defend it. How can you defend this evidence that you're using, or this argument that you're making? How do you defend it? What are some of the arguments people might make against you, and how would you prep for that? How would you prepare to be able to address them? Because arguing with somebody isn't necessarily admitting fault. It's a great way of proving that your position is the correct one, or at least the one that they should agree with, questions of correctness or truth aside. It's also kind of a wonderful way to play around with some of these terms of how funny language is, that there's a lot of precision in the Toulmin model, but it's also designed to operate within the densest fog banks of human reasoning. That even in a very confusing argument dealing with culture or something that's not precise or scientific enough for a logical argument, we can still get a lot out of that argument by using the Toulmin model to kind of understand what it is that we're being told, or where it is I can ask questions. Because, like he says, most arguments are just expressed, and we don't express all this stuff. We kind of take it for granted. So if people want to challenge it, they can say you don't have enough information, or you're making too big of a logical leap to your claim, or that warrant doesn't have the force to support that, or the conditions of the claim are different. Would you still support it? Or that kind of reasoning has been dismissed, and the backing can come in and show that kind of reasoning is valid. So I hope now you understand the Toulmin model a little bit better, and you can see some of my criticisms a little bit better with how the Toulmin model is used in general. Maybe we'll do some more of this. Maybe we'll do a little bit more Toulmin model work later. But this is the Toulmin model, how it works. Straight from the text, straight from the reading, from the man himself, Stephen Toulmin. What do you think about it? Leave a comment, leave a question. I will address it. And good luck with trying it out. Let me know under what situations you try it out and when you found it helpful. One of the best contributions to 20th century argumentation theory there is the Toulmin model. See you in the next video, and take care.